Thank you very much.
Senator Batters.
Thank you very much. It's great to be here today, and I'm wearing my Saskatchewan green just for the occasion. And it's wonderful to see the Minister of Justice. I'm sure that that's probably the office that I spent a considerable amount of time in when I was the Chief of Staff to his predecessor, Minister Don Morgan, and so it's great to see you here today. And then also hearing the reference to Professor Leeson. He was actually my third-year political science prof way back at the University of Regina many years ago, and we actually did a mock Meech Lake Accord, so it was nice to hear his name in this whole proceeding today. Minister Wyant, I wanted to start out with you, and I appreciate how your written submission, it pointed to how this constitutional amendment is entirely consistent with the role of the Senate, which plays such a key role in protecting Canada's regions. And I always view it as one of the most critical parts of my role to represent the concerns of the people of Saskatchewan. And as such, trying to help Saskatchewan receive tax fairness here, and more particularly, potentially $350 million is a very important task in that respect. So, Minister, could you please tell us more about how you believe this amendment is critical to our region of Saskatchewan being treated fairly as a full partner in Confederation? I think you're on mute.
Minister, you're on mute, yes.
There I go. I'll start again. Thank you very much, Senator Batters, for the question. Well, we don't believe, and as I've mentioned before, that we think that the provision in the Saskatchewan Act was really a relic of an earlier time. There's a modern transportation policy in place in this country, and we really believe that the province of Saskatchewan should have the full and formal ability to tax the CPR as it does with respect to any other company that's operating in this province. Certainly, the CPR takes advantage of infrastructure in Saskatchewan. Its employees take advantage of the programs that are available, whether it's health, education, social services. So we very much believe that as an equal partner in Confederation, that the province of Saskatchewan should be entitled to those tax revenues and not be penalized simply because of the fact, based on the date that we became a province in the country. And so given the historical significance of the railway, certainly to the entire West, and given the fact that the railway and its employees do take advantage of a number of policies and programs in the province of Saskatchewan, we believe that they should pay their fair share. Certainly, as an exporting province, the railway is important to the province of Saskatchewan, but we do believe that in order to ensure that Saskatchewan is treated as an equal partner, that we think that the tax policies of the province should conform and should be equal to the taxing policies with respect to the railway of the other provinces. And we believe that that's the case for Alberta and Manitoba. I may point out that we did reach out to the province of Manitoba and the province of Alberta to let them know what we were doing in terms of moving forward. We leave it to those provinces to decide how they're going to move forward with their respective challenges in this area. But we do believe that given the fact that the exemption was provided and the fact that the province of Saskatchewan really didn't have any input or input into the drafting of the Saskatchewan Act when it was put forward in 1905, that this really is an opportunity to correct what we consider to be a historical wrong and ultimately treat Saskatchewan as an equal partner in this country.
Thank you. And then I want to move on to the federal officials and to just say, so the government of Saskatchewan is not a party to the CPR contract that we're dealing with here. And as such, amending this particular part of the Constitution pertaining only to Saskatchewan is the only way that Saskatchewan has to eliminate that major restriction on its taxation powers. So to the federal officials, does the government of Canada agree with the position of the government of Saskatchewan that private law contract cannot be used to block a province's power to initiate a constitutional amendment to achieve equality with the original provinces of Confederation and British Columbia?
Well, I'll speak at a level perhaps of more generality. The Constitution is the supreme law of the land. And the Part 5 amending procedures are an expression of the sovereignty of the people of Canada, as the Supreme Court said, acting through their representatives, federal and provincial. There is an exhaustive or at least comprehensive set of amending procedures, and certainly this particular resolution comes within in our analysis section 43 within the Part 5 procedures, as Ms. Ottmer explained already. In terms of whether a contract can bind into the future constitutional actors, it's certainly not been our position. In a previous constitutional amendment in relation to Newfoundland, there was actually litigation, and I argue the position for the Attorney General of Canada in that case. That was before the courts of Newfoundland, where it was contended that there had been agreement on the terms of union in Newfoundland, and that agreement was perpetual and could not be overcome, that it was in the nature of a contract. In that particular case, the terms of union relating to denominational schools provisions in the province. And the Newfoundland courts, and particularly the Court of Appeal, put that argument completely to the side and said the Constitution is the supreme law. Every contract, of course, has to be interpreted in accordance with the law as it is amended from time to time, and in this particular case, in accordance with the supreme law. And so certainly the constitutional amendment was upheld despite the allegation that there was a contractual undertaking that could not be amended in this way. That case, by the way, is called Hogan versus Attorney General of Newfoundland and Attorney General of Canada, and the decision was rendered in 2001 by the Newfoundland Court of Appeal, and leave to appeal to the Supreme Court of Canada was denied.
Okay, thank you. And thanks very much. First of all, I just wanted to make a very brief comment dealing with what Senator Quinn was just talking about, and I guess I would say that it's the Senate's role, it's Parliament's role to deal with the Constitution. We're sitting here in the Senate's Legal and Constitutional Affairs Committee right now.
Senator Batters, you have 2 minutes.
Okay,
you have 2 minutes.
To consider it and in rare occasions to amend it. So that's our role as the legislative branch. So to Minister Wyant, I just want to make this issue crystal clear here. What happens if this constitutional amendment motion gets further delayed or in the worst case scenario does not pass the Senate?
Well, as I mentioned before, we're certainly going to continue to defend the interests of the province of Saskatchewan with respect to the claim that's been brought by the CPR. To the extent that the constitutional amendment may or may not have some effect on the litigation, we'll let our justice officials and the lawyers that represent the parties work that out in court, and ultimately there'll be a judicial decision on that. We do think, though, Senator, that the amendment is important from a not just a practical perspective, but really from a principled perspective. And I made this comment a number of times today that we believe that Saskatchewan should be treated as an equal partner in Confederation when it comes to their taxing authority, just as we think that Manitoba and Alberta ultimately, who we would expect to seek the same relief at some point, should be treated. And we're all equal partners, and you'll recall that there's been a number of things that have happened over the years that have given Saskatchewan a more equal voice. We had the Natural Resource Transfer Agreement back in the 30s, which gave Saskatchewan control over its natural resources. That was fair. And we think that giving the taxing authority back to the province is fair. And we think that it's unfair that the exemption exists. Things have changed, and I think it's been noted by a number of witnesses that things have changed significantly in the 141 years since that contract was signed, and we've made specific reference to a number of things. But in terms of where we go from here, the province of Saskatchewan, and I've given instructions to the Ministry of Justice to continue to pursue the defense of the litigation that has been brought from the railway, whether or not the resolution that dichotomy with respect to the issues today, the Constitution on one side and the litigation on the other.
Thank you.
Thank you, Senator.